You know, when you go to a play or a movie, you completely buy into the illusion. The actor on stage pulls out a sword, and even if you logically know it's just painted wood or dull aluminum, your heart still races.
Oh, absolutely. In the context of the scene, the threat feels completely real.
Right. The illusion creates a very genuine emotion.
Exactly. It's that suspension of disbelief.
Yeah.
You react to the perception of danger, not the objective reality of the prop.
Right, right. But we usually expect the law to be the exact opposite of theater. We expect the justice system to care only about objective reality.
Yeah, like cold, hard facts.
Exactly, like a doctor looking at an x-ray, right?
Yeah.
It's either a broken bone or it isn't. No illusions, no theater.
That's the expectation, certainly. I mean, we want legal categories to be binary and completely visible.
But then you step into the world of criminal law, specifically the definitions around robbery, and suddenly you realize the law actually cares deeply about the illusion. So welcome to this deep dive.
Glad to be here.
Today, we are taking a fascinating legal problem for you to ponder and looking at how the justice system untangles reality from perception. We're going to figure out what exactly transforms a standard run-of-the-mill robbery into an armed robbery.
It's a really tricky boundary.
It is, because here's the question for you as we get into this. If a robber uses a completely fake, homemade toy, are they legally armed? Where does the law actually draw the line?
It is a brilliant question. And it takes us into some genuinely murky waters. To map out this analytical path for you, we're going to dissect the legal doctrine defining a dangerous weapon.
Okay.
And we aren't just going to look at the theory. We're going to apply a strict element-by-element analysis to two key Massachusetts cases.
Right. Commonwealth v. Powell and Commonwealth v. Howard.
Exactly. By doing this, we'll map the precise boundary between being actually armed, apparently armed with a fake object, and apparently armed with absolutely nothing.
Okay, let's unpack this. Before we get into the wild stories of these specific cases, set the baseline for us. In the context of an armed robbery charge, what exactly makes something a dangerous weapon?
Well, the foundational rule here is actually beautifully pragmatic.
Yeah.
The general rule states that a dangerous weapon includes items that are naturally inherently capable of causing serious injury or death.
Like your obvious stuff.
Right. We're talking about your loaded handguns, hunting knives, brass knuckles.
The objective reality, the actual broken bone on the x-ray.
Precisely. But, and this is the crucial pivot, the general rule crucially includes items used or displayed in a way that they reasonably appear capable of causing serious injury or death.
Ah, the theater prop. So the law says the illusion can be just as legally potent as the reality.
Yes.
Let's analyze Commonwealth v. Powell. First, what are the legally dispositive facts?
Okay, so the facts are wild. Walter L. Powell robbed a Plymouth gas station at around 10:30 p.m. He threatened the cashier, Teresa Campbell, saying he had a gun and would shoot her. He had his right hand on an object under his jacket with just the tip protruding.
And what did she think it was?
Well, the victim thought it looked like, quote, 2 wooden sticks, but she was terrified. Powell stole $170 and forced the victim to walk with him outside for 5 to 10 minutes.
Wow, that's terrifying.
It really is. But here's the kicker. Police later found the object. It was a replica double-barrel shotgun made of wooden dowels, a wood stock, and get this, a clothespin for a hammer.
A laundry clothespin? Are you kidding me?
Nope, completely inoperable wooden toy.
That's crazy. And what was the core legal issue?
The issue was this. Did the trial judge err in denying a motion for a not guilty finding on the armed robbery charge? Specifically, can a completely inoperable wooden replica of a gun legally qualify as a dangerous weapon?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule has two distinct elements. First, the defendant must possess an actual physical instrumentality. Second, the object must either be actually capable of inflicting serious injury, or, under the surrounding circumstances, it must reasonably appear capable of inflicting serious bodily injury or death to a person of average sensibility.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, possession of a physical instrumentality?
Right, so let's do a mini IRAC here. The sub-issue is, did Powell possess an actual object?
Right.
The sub-rule is that the statute requires the presence of some physical item. It can't be thin air.
Makes sense.
So for the application, police recovered the wooden dowel and clothespin contraption that Powell had under his jacket. So the conclusion is that the first element is totally met. He possessed a physical thing.
Understood. Now, what about the second element, reasonable appearance of danger? Because, let me just push back here. if I point a banana inside my coat pocket, is the court really saying that's legally the same as a loaded weapon?
It's a funny visual, but yeah, it perfectly isolates the test. So, for our second mini IRAC, the sub-issue, did the wooden toy reasonably appear capable of causing serious injury?
Which it physically couldn't.
Right. So the sub-rule is, if an object is incapable of inflicting injury, it is a dangerous weapon only if the victim reasonably believed it was real based on the circumstances.
The stage setting.
Exactly.
Mhm.
So applying that to the facts, Powell explicitly claimed to have a gun. He gestured to an object the size and shape of a gun under his jacket, and the victim complied out of a genuine fear of being shot.
So the context does all the heavy lifting.
Right. Conclusion. The second element is met. It was entirely reasonable for the victim to believe the object was a real gun in that terrifying moment.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Judicial Court affirmed the armed robbery conviction. Because Powell possessed an object that reasonably appeared to be a deadly weapon, he was armed with a dangerous weapon under the law.
Okay, so the illusion backed by a prop counts. But this raises a huge question. If the appearance of danger and the victim's fear are what really matter, what happens if the robber has no object at all?
Wow.
They are just an incredibly convincing actor. Let's analyze Commonwealth v. Howard. First, what are the legally dispositive facts?
Okay, so the facts in Howard. The defendant robbed a victim, threatening that he would, quote, pull the trigger if she did anything foolish.
A very clear threat.
Very clear. But the victim saw no object or gun. And here's the key. Police arrived during the robbery and arrested the defendant right on the spot.
Instantly.
Right. He had absolutely no weapon or object on his person. Completely empty pockets.
And what was the core legal issue?
The issue is, can a defendant's mere verbal claim of having a weapon, which engenders fear in the victim but is entirely unsupported by any physical object, sustain an armed robbery conviction?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule is that the crime of armed robbery does not extend to someone who is only apparently armed with nothing.
Okay.
The rule hinges on one strict element. The Commonwealth must prove the defendant was armed with some physical instrumentality that presents an objective threat of danger.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, possession of a physical instrumentality?
Okay, mini IRAC time. The sub-issue. Did Howard possess an instrumentality?
Right.
The sub-rule.
Right.
A defendant must have some physical object in their possession. Words alone are legally insufficient.
Even if the words are terrifying.
Exactly. So for the application, Howard was arrested at the scene without an opportunity to dispose of a weapon, and he had no physical object on him whatsoever.
Not even a clothespin.
Right, nothing. So the conclusion, the element fails entirely.
And after analyzing all the elements, what was the court's final conclusion?
The court ruled the conviction for armed robbery was not warranted. They recognized that a bluff causes the exact same fear in a victim as a real gun.
Which is so true. The trauma is identical.
It is. But they nonetheless held that the legislature has not criminalized being apparently armed with no actual object. It's just standard robbery.
Okay, here's where it gets really interesting. I want to test this boundary between Powell and Howard. We have the necessity of a physical prop and the necessity of a reasonable illusion.
Okay, lay it on me.
Let's test this with a visceral hypothetical, just an unforgettable, kind of gross scenario to see if we truly grasp the rule.
I'm ready.
Let's say a bank robber sneaks a severed, bloody mannequin arm from a department store under his shirt.
Oh, wow.
Yeah, and he points the stiff plastic finger from inside the jacket so it looks exactly like the barrel of a shotgun, and he threatens to shoot the teller. Is that armed robbery?
That is, wow. That is a deeply disturbing image.
Mm.
But let's apply the elements to this visceral hypothetical. Element 1, physical object.
Did he have one?
Yes. The mannequin arm is an actual physical instrumentality, unlike in Howard where he had nothing.
Okay, so he clears hurdle 1. What about element 2, reasonable appearance?
All right, so we look at the context. Yes, because it is concealed to look like a gun barrel and accompanied by a verbal threat, the teller would reasonably perceive it as a deadly weapon, just like the clothespin in Powell.
Right. In the panic of a bank robbery, you aren't doing a material analysis of the bulge in the jacket.
Exactly. So conclusion, yes, armed robbery. The absurdity, or like the grossness of the actual object, is totally irrelevant. What matters is physical presence plus the objective appearance of danger in context.
Wow. Okay, we covered some wild ground today. Before we wrap up, could you synthesize the rules from today's deep dive into a practical, step-by-step diagnostic checklist? Like something you could use for issue spotting on a law exam or in practice?
Absolutely. Here is the stripped actional checklist. Step 1. The instrumentality check.
Okay.
Did the defendant possess an actual physical object? If the answer is no, if it's mere words or bluffing, stop the analysis. It is unarmed robbery, just like Howard.
Got it. No physical thing, no armed robbery.
Right. Step 2. The intrinsic danger check. If an object is present, is it naturally capable of causing serious injury or death?
Like a loaded gun or a knife.
Exactly. If yes, it's armed robbery. Done.
And what if it's a fake?
That brings us to step 3, the circumstantial appearance check. If the object is fake, inoperable, or harmless, like a wooden clothespin toy, did it reasonably appear capable of causing serious injury in the specific context of the robbery?
Right, looking at the whole stage play.
Yes. Analyze the defendant's gestures, words, and the objective reasonableness of the victim's fear, like in Powell. If yes, it's armed robbery.
That checklist is incredibly clear. It really imposes order on what is otherwise totally chaotic human behavior.
It really does.
Well, I want to leave you, the listener, with a final provocative thought that builds on these rules.
Oh, I like these.
If technology advances and a robber uses a smartwatch to project an ultra-realistic 3D hologram of a gun to terrify a victim, is a projection made purely of light a physical instrumentality under Howard, or just an illusion?
Oh, man, that is a tough one.
Right. Where does the law draw the line when objects become entirely digital? Something to think about. Thank you for joining us on this deep dive.